All right, everyone, we're going to go ahead and get started. My name is Alex Sharastani. I'm the founder of the Journal of Law and Technology. Welcome to Unwarranted Surveillance. We have professors Bobby Chesney and Steve Vladek, and then Shahid Buttar of EFF. Shahid. My apologies. Shahid of Electronic Frontier Foundation. Welcome, everybody. We're going to have a good talk about FISA. I'd like to get started with each of you giving a brief introduction about yourselves, please.
Okay. My claim to fame is that Alex was a 1L in my common law class a few years back. Beyond that, I'm the academic affairs dean here, and more relevant to today's topic, I've been studying and writing in this area and related aspects of national security law since about 2000. I've served as a consultant to the intelligence community through a body that no longer exists called the Intelligence Science Board. It was a bunch of scientists and technologists who were outside academic advisors to the Director of National Intelligence, and before that, the CI Director. Like every group of scientists and other types of people, you gotta have a lawyer too. So I was involved in that.
Great.
Shahid. I'm the Director of Grassroots Advocacy at the Electronic Frontier Foundation. I haven't been working on these issues quite as long as Bobby. I probably started writing about mass surveillance in 2005 or 6, particularly after the first of the whistleblowers revealed it to the American public. I've done a fair amount of lobbying, a lot of writing, a lot of organizing. If I had a claim to fame, as it were, it was getting arrested and after a Senate hearing, asking the Director of National Intelligence how he had evaded prosecution for perjury when, at the time, Eric Garner had just been killed in New York extrajudicially on the mere suspicion of committing a far more trivial offense, and the juxtaposition, impunity for grave offenses on the public record by powerful officials with the worst consequences imaginable for powerless people committing trivial offenses that are merely suspected. No one's ever answered the question, but I'm excited to be here.
My bio is much less interesting than that. So let's see. I basically just ride Bobby's coattails. That's how I've gotten where I am in the world.
The Supreme Court. Right?
Yeah, you know.
This is the guy who argued in the Supreme Court the other day.
Well, that wasn't a surveillance case. So I've been involved in I've been involved in the surveillance side of things probably since about when Shahid got involved. I came to the world of national security law more on the detention and military commission side of things, and it really wasn't until after we learned of the first major, warrantless surveillance program, F9/11, that became part of the umbrella and the bailiwick as well. I'll confess, when I was the summer after my first year of law school, I was an intern in DC, and I went to this hearing, and it was essentially a committee hearing, and they were talking about FISA. And I just couldn't understand why everyone was mispronouncing the word visa. I said, what was going on? In the ensuing, 16 years, I've learned a few things about how this works. Co-authored a casebook that covers these issues in some detail. Argue about the need for more adversarial process in the FISA court, etc. So that's me.
Great. So we're going to have a great discussion today. For those of you who haven't joined us before, the way we like to run our presentations is it's more participatory. So instead of holding questions for the end, we sort of take them as the talk is going on. So if you have a question, feel free to raise your hand during the discussion. And if there's a natural break, I'll try and get to you. But bearing in mind that we have 3 very knowledgeable people here, so if they're deep into it, I might defer your question to a little bit later. So let's get started. With a deceptively simple question, what's the purpose of the FISA court, and does it do its job well?
We should probably, why don't we start with the grand bargain?
Okay, so I'll set the table a little bit, and then we'll all weigh in with the more normal take on it. Some key context here is that if you go back prior to 1978, there's no Foreign Intelligence Surveillance Court, no Foreign Intelligence Surveillance Act, no statutory or judicial framework for foreign intelligence gathering at all, even when it's touching on the privacy interest of American citizens. And so what you want to imagine is sort of over the course of the 20th century, with technological change constantly generating sort of additionally tricky fact patterns, the law is working out where the protections of the Fourth Amendment are and where they don't run. Maybe Congress steps in with protections all relating to criminal investigation. But in the background is some amount, and over time a growing amount, of domestically located investigation for foreign intelligence purposes, and sometimes for domestic intelligence purposes, and thus this sort of conceptual distinction being drawn between what law enforcement investigators do, trying to build a case for public prosecution, and what intelligence collectors do, trying to gather information to inform government decision-making, which may or may not turn into prosecution at some point, but may just be about informing decision-making. And again, I want to underscore here that some of this activity, of course, will take place overseas. Some of the intelligence gathering will take place within the United States. But the way the government would talk about it would be that if it's foreign intelligence, if the target of interest, the thing you're trying to learn about, is about a foreign power of some kind and their actions and interests, you might collect that by following a Soviet official inside the United States or an American citizen who you think knows something about the Soviets' intentions. That would be domestic, but it's foreign intelligence gathering. So there's sort of this bifurcation in these different conceptual categories, and all the legal protections for privacy in the United States are being built up to the extent that they are around the criminal investigative process, and then intelligence collection is just kind of going on in the black box, and the public doesn't really know about it. And there's some stuff that comes to light. Suffice to say that, especially in the early 1970s, a large number of leaks and congressional investigations, this whole set of events occurs that brings out into the public's eye that lots of stuff like this happens. And in the same period, there's a Supreme Court case which deals with a prosecution that originated as just a warrantless intelligence investigation in Michigan. And the Supreme Court actually says, that case had no foreign intelligence angle to it, so we're going to say that some form of warrant requirement applies even though it wasn't originally a prosecution. So all this change is starting to occur, this pressure for change and to create some kind of system to regulate this activity in the 70s as people began to understand these things are happening, the public becomes more involved, Congress is getting more involved. It's the aftermath of Watergate and Vietnam, so you have kind of a reform-minded Congress. And as Steve used the phrase a moment ago, grand bargain. So this kind of captures the idea that there's this moment of disequilibrium that we reach by the 70s when it becomes apparent that NSA and FBI and others, they do stuff in the name of intelligence gathering inside the United States, and they don't think the Fourth Amendment applies. And if it's foreign intelligence, it's not clear that it does according to the courts, and Congress hasn't stepped in. So the bargain is, how about legislation to address just the stuff that's foreign intelligence collection where there's strong U.S. equities, where it's taking place here or a U.S. person here is a target, that sort of general idea. Let's create a system that will subject that to judicial oversight akin to a warrant. It's going to be different, but it's going to be somewhat like that. And the rest of it, the overseas stuff, where there's a satellite dish in the Australian outback pointed at the Soviet Union or China, we're not touching that. The NSA go off and do that. That's not being judicialized. But the stuff that's domestic, the idea was, let's subject it to a process. And the process boils down to the creation of a special body of otherwise ordinary Article 3 federal court judges who are empowered to grant not a warrant, but a warrant-like device called a FISA order. And the idea is the government has to come in on an ex parte, in-camera basis and make a probable cause showing that the person they want to target is an agent of a foreign power. Now, there's no opposing side to argue the other side of the case. And even though that's how it is with the regular criminal investigative warrant, at least in that context, it's likely that later on there'll be a suppression motion when the person's eventually prosecuted. That's not likely to happen in most FISA cases, but nonetheless, otherwise it's a little bit like the warrant system. And again, the idea is kind of a grand bargain. The government goes along with accepting this as a new thing under the sun, judicial oversight of foreign intelligence collection. But they're kind of empowered by it. They're legitimized by it. In fact, now, once they have the FISA order, that gives them some ability to do some compulsory process for technical aid. And that sort of creates a new equilibrium, I think it's fair to say. Whether it was a good equilibrium or not, I'm not telling you. But it kind of restores equilibrium. And for a number of decades, until the moments that Shahid mentioned a moment ago, after 9/11, you have probably about 25 years of, that's kind of how the system works. And then maybe you could weigh in with sort of like how the equilibrium kind of comes undone with public revelations around 2004, 2005.
Sure. So December 2005, an AT&T whistleblower by the name of Mark Klein reveals essentially that the telephony system has been at that point, and I think to this point, still widely co-opted, that NSA was collecting essentially copies of content and at least metadata from the telephone system. The further revelations about internet surveillance took another 8 years to come to the fore in the wake of the Snowden revelations that I think people might recall from not very long ago. A couple of things to note here. I think Bobby's absolutely right that the equilibrium, let's say, that was struck in the late 70s aimed to balance a process by creating opportunities for judicial intervention and what previously was unfettered, secret, unaccountable executive activity. The unaccountability and the secrecy of the executive action essentially reprised itself in the wake of the 9/11 attacks, and by 2005 and certainly by 2013, what we'd seen was the sort of full metastasis of the prior paradigm, which is to say executive action without judicial sanction. Going back to Alex's sort of original question, what is the purpose of the FISA court? Does it perform it well? I would say that the purpose of the FISA court ultimately is to confer a veneer of legitimacy on ultimately unconstitutional activity. And you really can't square domestic intelligence collection with the requirements either of the Fourth Amendment or the First. People under-regard one of the claims. We have several cases challenging the NSA's dragnet at the Electronic Frontier Foundation. One of them, First Unitarian Church of Los Angeles versus Clapper, I believe, essentially makes the First Amendment angle relates to the right of anonymity recognized by the Supreme Court as intrinsic to First Amendment rights in the context of a series of cases in which people were seeking information about the NAACP's members in the South. And at the time, and I suspect even perhaps still today in some parts of the South, the fact of one's membership in that particular organization might render some people unsafe. The Supreme Court recognizing that the transparency into individual association placed people's safety at risk and thus inhibited freedom of expression, recognized a First Amendment interest in anonymity as to one's associations and political perspectives, affiliations. That's exactly what mass surveillance precludes. And so to construe the surveillance apparatus as strictly an offense of Fourth Amendment privacy interests, I think vastly underregards the extent to which freedom of expression and through it democracy are implicated. I would suggest to you that privacy is the least of the values that surveillance offends. Ultimately, what it burdens are autonomy, agency, dissent, and ultimately democracy. And that's a lens of the equation that I think is usually ignored entirely. It's certainly not an angle that Congress has ever considered, and I think it's one that lay very much at the concerns of the whistleblowers and of the advocates who've been trying to defend your constitutional rights in the face of this sordid regime for the last 17 years.
So I guess I would say, I think it's really helpful whenever we talk about the FISA court to differentiate between the two very different kinds of things that the FISA court does. What Bobby described is what we often shorthand as classic FISA, or if you want to be hyper-technical, Title I FISA, which is an individualized probable cause order based upon a showing to a neutral magistrate of probable cause to believe the target of the order is a nation of foreign power. I think it is an open and really important question whether those orders satisfy the warrant clause or whether they're constitutional because they fall within an exception to the warrant clause for foreign intelligence surveillance. The Supreme Court has never settled that question. And I think that's perhaps where there might be some daylight among the three of us. But I think that part of what the FISA court does, with all due respect to Chairman Nunes, is the much less controversial, structurally problematic, to me at least, part of the FISA court's role in our system, because it is so deeply analogous to the role that magistrate judges play in ordinary law enforcement investigations. Starting in 1998, but really much more aggressively after 9/11, Congress gave the FISA court additional responsibilities, additional roles to play. And the two that we're most familiar with are the issuance of what came to be known as Section 215 production orders to businesses for business records. This is where the phone records program found its ultimately unconvincing statutory hook. Under the 2008 FISA Amendments Act, directives issued to electronic communication service providers for far more, I think, open-ended, right, programmatic collection of surveillance. And here's the thing about both of those authorities. Those are not about individual targets, right? Those are not about the government going to the FISA court and saying, here's a particular person we suspect of being up to no good, right? Whether it's foreign intelligence no good versus criminal no good. Those are much more generalized, almost administrative surveillance orders, for better or for worse. And I think what Congress really was never fully forced to account for was how those shifts in the role of the FISA court affected the calculus behind the grand bargain, right? And affected the original role that Congress intended the FISA court to play in sort of alongside the then newly established intelligence committees, the House and Senate intelligence committees. So to me, I actually think it's a very different conversation if we're talking about classic Title I FISA, where I think historically the record's actually, not perfect, but with all due respect to Carter Page, pretty good. And the sort of programmatic and bulk collection authorities, which raise, I think, far greater privacy, civil liberties, associational and expression concerns that really have not ever been as fully fleshed out as I would like them to have been. So to me, when Alice, when you ask, what is the FISA court and does it work? Right, I think the FISA court is very good at the job it was originally created to do. And I have real concerns about the job that the jobs Congress added along the way.
Let me add something, kind of picking up the theme of the ways in which the original equilibrium becomes unstuck. So obviously part of it is the sort of changing strategic environment and the big push on counterterrorism. Part of it is the concrete legal developments. We should emphasize, especially for this group, the technological change that creates a particular state of affairs. I think this goes to what Steve was describing as the novel programmatic, non-individualized Section 702 stuff, where it's important to emphasize, at least at the surface layer, the actual targets of the collection are supposed to be non-U.S. persons located outside the United States, which sounds like what I was describing earlier as the world out there where there weren't strong U.S. privacy equities, or expressive equities, I would add, in acknowledgement of the point. But technological change created a circumstance in which over time, thanks to the growing amount of information that would be found, for example, the best, most accessible example would be emails, non-U.S. persons who maybe only communicate with other non-U.S. persons, but using the communication platform that an American company might provide, so say a Gmail address, creating this interesting situation where you have the potential for what was sometimes referred to in the government as a home field advantage. That is, it's an American company. They might, for patriotic reasons, be willing to cooperate, or later on, once there's the 702 system, we can oblige them through court process, judicial process. We can make them cooperate, and damned if we can't get direct access through the company to this non-U.S. person's foreign communications. Now, I want to quickly get to the next cut on that same issue, which is it's not just going to be foreign to foreign communications, but do recognize that's the central model. It is conceded by the government that also along the way you're going to get foreign to U.S. or U.S. to foreign communications, and then incidental collections that might even be U.S. to U.S. So it starts getting very complicated. It's not just foreign to foreign collection that occurs, but the point is that was not the state of affairs in the 70s when they were first creating the FISA system. There was no scenario in which you imagined that there might be a key Soviet target using a particular telephone number, and it's overseas. It's all about that person's day in, day out communications overseas. But hey, you can go to AT&T in New York and they actually have all of the records of it. That was not the technology.
Babushka Bell.
What's it?
Babushka Bell.
Babushka Bell, exactly. So eventually, you get this much more complex data transfer and information environment that we've currently got in the telecoms world. And I think the best way to understand 702 is it's an attempt to create this wholly different and distinct and very distinguishable, and obviously in many ways more controversial, new equilibrium that's got some judicial involvement, but this time it's not individualized. Right. It's done on I'm sure we'll get into the details, this sort of programmatic basis, and raises a lot of questions that original FISA for the most part, doesn't really raise, or at least I agree with how Steve characterized it.
If I could say a couple of things here. One, I would certainly agree that Title I versus 702 present profoundly different issues, and if we were to evaluate the performance of the FISA court, it's very different answers depending on those contexts. On the theme of where the grand bargain sort of went off the rails, in the wake of the 9/11 attacks, there was some criticism of the intelligence community by bodies including the 9/11 Commission that related particularly to the agency's failure to share intelligence information across their respective stovepipes. And while faults of intelligence sharing were the object of the political consensus, the agencies, at that point with the endorsement of the then administration, internalized a mandate for collection that to some extent sidestepped the documented problem that the 9/11 Commission found. So basically, if we had a problem of sharing information that we had, what the agencies interpreted that as was a mandate to then collect it all. And so while Bobby's right that the nominal purpose that is authorized by the Foreign Intelligence Surveillance Act, FISA, relates to foreign intelligence collection, the operational practice of the agencies, as we learned particularly from Snowden and Mark Klein and others in addition to them, was that the agency collects it all. And two particular programs I'll just note just to lay the sort of facts, and we can talk about their normative implications later. Upstream collection is the sort of systematic collection of data en masse as it moves through the internet's choke points. PRISM is another program also conducted under Section 702 of FISA, through which the agencies gain access either through the front door or the back door of data held by major internet companies. All the names you might have heard of, the Amazons and Googles and Microsofts and Apples and Yahoos of the world. That sort of collect it all mentality, I would say, is what particularly constitutionally damns the apparatus, the new one that the equilibrium that Bobby had mentioned. There certainly is, I think it's fair to describe an effort to strike a new equilibrium. I think the question before us as a culture and as a legal system is to what extent does that attempt at a new equilibrium satisfy the warrant requirement of the Fourth Amendment or the anonymity protections of the First Amendment, or for that matter, just the checks and balances that the Constitution as a whole was created to insist upon. Last thing I'll say just before I pass it back to Alex or Steve, if you want to jump in here, was there's another recurring factor that plays here, and I will describe that as secret interpretations of legal powers by government agencies. And I'll even reflect on a brief that Steve and I had a chance to work on together, an amicus brief in a case, Obama versus Hedges, more squarely in Steve's other wheelhouse with respect to military detention. But the central thrust of the brief was, if in the context of a facial challenge to a military detention statute, the judiciary abdicates the responsibility to reach a decision on the merits, there will be no opportunities to reach as applied decisions because the executive branch will game the system. And we look to the secret interpretation, for instance, of Section 215 of the Patriot Act. That's the business records provision that Steve was talking about. It was interpreted in secret by the agencies in ways that even the authors of the Patriot Act never recognized until Edward Snowden came forward. And when you have Republican former chairs of the Senate Judiciary Committee authoring legislation to peel back their prior legislative highlights of their careers, you know that something has gone off the rails. And I think that secret interpretation, in addition to the sort of bait and switch of, is it sharing, is it collection, what exactly was the problem here, and let's fix a non-problem, ignore, or perhaps fix through other mechanisms, a real problem, and all the while permitting this sort of nefarious, in the shadows interpretation, immune from congressional oversight, immune from judicial review, and effectively immune from legislative correction.
So just really quick, because I want to move on. But I do think, I think that there's actually a deep consistency, right, through everything that the three of us are saying, which is, the FISA court doesn't make a whole lot of law when it issues a probable cause order, right? There's no precedent set by probable cause order. There's almost never formal legal findings beyond the probable cause determination, which is always case specific. And so the secret lawmaking that Shahid is rightly, I think, worried about is a phenomenon of these post 9/11 additions, right, to the role of the FISA court. And so, I think we have to be careful to separate the sort of, do we agree with the substantive interpretations of the government surveillance authorities that are being reached in these cases? And, and then separate that question from, do we think there's meaningful opportunities to actually flesh out the substantive legal authorities and litigate them on the merits, right? And I think that part of what's happened in the last couple of years is those two conversations have been blurred together, as we've also blurred the classic FISA versus 702 and phone records FISA, right? And I think that they're actually two different conversations that should be had separately for the two very different kinds of things the FISA court does. So that's 4 conversations.
Hopefully we get to all of them today. But it seems like we're scratching on the surface of an issue that I assume most people in the room want to talk about, is how the 702 collection is interacting with warrant requirements. So is this collection where other agencies can get access to this information outside of a warrant requirement a trend? Is this something to be worried about? Where is the legal authority coming from? And just getting your thoughts on that.
So I'll say something about that by way of setting the table and also connecting it to something that Shahid said about, so I was fascinated that you set it up as a juxtaposition of the 9/11 Commission-ish mandate to cross the streams and share information, and set it up as that was really what the mandate or the diagnosis of the problem from 9/11 was, and instead they kind of went for let's just have more dots rather than share the dots. Whereas I would have thought, like, to me, it's very much, I agree that they went out to gather more dots, but I also think that they wholeheartedly embraced the share the dots too, and it wasn't an either or, it was all the above, which actually leads to I think it's probably less of a problem than I'm sure you might think it is, but it leads to this question of, now that there's more data coming in, including through the 702 programmatic collection, upstream and prison type stuff that we're talking about, even if one is okay with NSA getting that information for purposes of the NSA foreign intelligence analysts, who then filter things into things that go to the President's Daily Brief, that sort of deal, or to the National Counterterrorism Center, why is it also okay that it turns out FBI criminal investigators can access it? That's been, I think with much justice, that's been the biggest flashpoint, I think, of the past year or so, as we had this incredibly long...
Until a month ago.
This long and convoluted process of the statute that we're all talking about, 702, it had a sunset. It's had several rounds of this. The most recent one was December 31st this past year, and this whole back and forth took place about, okay, what changes, if any? Is it going to be just a clean renewal? Is it going to be a dramatic paring back of things? And there were a couple of categories of concern people had. So some sort of from the Trump camp wanted to make it be about unmasking, which isn't even really a topic that fits with 702. But the one thing that I think most people who are really good faith participants in the argument all agree that's interesting and important and a hard question is, what about if you let NSA get this, who besides the foreign intelligence analyst can type in a name and say, what have you got on Alex, and see if you get a hit? Because it did come out through the good work, especially of the Privacy and Civil Liberties Oversight Board several years back. It came out that even to a degree that I don't think the Foreign Intelligence Surveillance Court had fully appreciated, criminal law investigators at the FBI could nominate names and in fact say, hey, run this through the database. It's the fruits of this foreign intelligence collection. Do you happen to have any conversations with Steve Vladeck in there? Oh, well, yes, here's 3 hits. Let's look at those. So for critics, that's when you hear backdoor searching, you've surely heard that. That's the idea, right? And the idea is that they didn't have a warrant to do what criminal investigators are supposed to do in order to be able to surveil Steve Vladeck. So they go through the back door where there's some other information that was already in other government hands and say, hey, you guys have any of this? Can I see it?
But other information that they could not lawfully have obtained directly, right? That they only obtained incidentally.
So that's the backdoor characterization. Now, from the government's perspective, the response, it sort of starts with that information sharing mandate, saying like, hey, we acquired the conversation that John Doe overseas is on the phone with Steve Vladeck. We acquired that through let's assume, the completely legitimate following of the Section 702 rules. Once we've got it, aren't we in trouble if we don't share it? That's the mandate of the 9/11 Commission report. We're supposed to share, no more silos. We didn't get it on purpose for the criminal investigation. It wasn't some handshake deal, no reverse targeting. It just happened to be that we got it. But once we do have it, as long as we got it legitimately, isn't it, so this is the government position I'm trying to advance here. I'm not saying this is necessarily how I feel. But whoever's got it in government, whether the DEA got it through one of their means or some state and local law enforcement got it, once it's there, lawfully acquired at step one in time, don't we want real broad sharing? Isn't that what the 9/11 Commission said? And so those are the sort of the, depending on how to get a real appealing fact pattern in your mind, like what if they incidentally pick up some sort of child pornography stuff? Don't you want them to get that in the hands of the FBI law enforcement person who cracks down on the child pornographers? Well, you put it that way, it sounds pretty good. So you have this sort of irresistible force, immovable object type clash between the appeal of the intuition that once you've got it lawfully in the first instance, you ought to get it to the hands of people who have a law enforcement interest there, at least if they ask. On the other hand, we have these rules for the law enforcement investigators. They're supposed to make them follow certain procedures for the benefit of all of our liberties in a free society. And there does feel like this little sort of backdoor sneak around element to it as well. So I think that's why it proved to be such a hard and intractable issue. And before we get into how they solved it, I think maybe we should actually talk more normatively about that tension. We can tell the group in a second, like, okay, so what's in the new statute?
But just with respect to the, I think that was
was it a fair description?
Absolutely. No, I think it was absolutely fair and accurate. And I think the idea of particularly the intelligence community adopting a sharing and collect it all posture, I'll certainly buy that, but it was all of the above. And I think that the tension grows sharper, not only in the context of the warrant requirement, but also the rules of evidence in criminal proceedings, because it's not just the case that DEA, for instance, is querying NSA databases. I'm thinking of parallel construction here. There's this sort of process and increasingly routine practice of using that intelligence that was gathered without a warrant in the traditional sense, that was, hey Drew, using that information that may have been gathered and then surreptitiously finding other ways to obtain the same information and then presenting it to criminal courts without being forthright about its origin. And this idea essentially of parallel construction, constructing a theory of evidence through a parallel process after first identifying intelligence information that would be inadmissible in court because it cannot meet the rules of evidence or satisfy the warrant requirement, that's sort of a further hole in the bucket perhaps. If it were just a matter of agencies querying NSA data, from a constitutional perspective, there would still be a problem with that, though I understand that it would at least reflect perhaps a response to this perceived mandate in the wake of a grave incident. That notwithstanding, we should recognize in the same way that democracy is impacted in the sort of externalities here, I think also the rules of evidence and the integrity of the criminal justice system is threatened by this sort of creation of a whole new way for the government to seek. And not just, I guess I'm thinking less here about the collection, but more of the querying and deployment phase of that information.
Can I just quickly pile on that? So I think it's worth restating what you just said about distinguishing collection at step one. So the information's out there, the government goes through some process or other, statutorily defined or otherwise, and gets their hands on the information. And then the querying is sort of the stage two process where the information is now in the government database somewhere. So it's in an NSA database on this example. And then there's somebody who wants to run a search. And it's an interesting idea and I think somewhat of a novelty to think about the idea that maybe the Fourth Amendment requires a warrant not only sometimes at the collection stage, but maybe even after one part of government gets it, the other part has to have what amounts to a warrant for internal access. And I'm not saying that's wrong. In fact, I kind of like at least some of where the new statute sort of turned out. But I do think it's kind of novel. I can't think of another example where we currently have existing internal warrant barricades between one part of government and another.
But part of why that's true, of course, is because in the sort of analog era, right, incidental collection was not the kind of privacy harm, right, on the scale that it is today, right? I mean, so one of the things that I find sort of, I mean, this whole context is happening against a doctrinal backdrop, where the government and Congress in designing these authorities are certainly capitalizing on, right, the state of Fourth Amendment doctrine. The state of Fourth Amendment doctrine is, or at least long has been, that if the government incidentally collects something, even if the information, even if the individual in question had an expectation of privacy in that information, the government incidentally collects that information pursuant to an otherwise lawful means of collecting the information, it's not protected by the Fourth Amendment, right? But there's an interesting district court opinion by Judge Sand from 2000 in the Bin Laden case, where he says, the whole sort of premise of incidental collection is that it really is accidental collection, right? That the government that they were up on one phone line and they weren't expecting that the wife was going to use the husband's phone to orchestrate the husband's murder, right? But it was purely accidental. It was not reasonably foreseeable that they would uncover this evidence of other criminality incidentally, right? Not everyone agrees with Judge Sand that incidental actually means accidental, but it's a view that's out there. And on the view that incidental means accidental, what happened under 702 is not accidental, right? The incidental collection under 702 is knowing and intentional, right? In the sense that the government is well aware and indeed concedes that it has no ability to not collect at least these MCTs, these multi-communications transactions, without incidental collection. I've now set Bobby off.
Well, I'm worried that could be misunderstood. I know you're not suggesting, but it makes it sound a little bit as if 702, it's all kind of a ruse, like, well, we're going to say we're going after these foreign targets, but what we're really doing is setting up our buddies in the criminal investigative side.
No. So I'm not saying this is reverse targeting, right?
Right. I want to be really clear.
No. It's not. No, my point is just that if you are sympathetic to Judge Sand's view of incidental collection, that the whole theory only makes sense if it's really an accident, right? 702 collection, the incidental collection pursuant to 702 is not accidental, right?
I don't think it's distinct like you're saying, because so you're going up on a regular criminal Title III wiretap, you know you're going to have some incidental collection. You are absolutely going to hear some pizza orders and some calls to some relatives that are just not going to be.
But by the target, right? I mean,
you know that someone else might get on the phone too.
You know that someone else might get on the phone.
Even that's not the same. I mean, the scale of incidental collection.
So I think scale is more
so that was the second thing I was going to say. So the first thing is the distinction between accidental incidental collection and no incidental collection. The second thing, and this is Judge Leon, right, in the phone records case, is that there's also a difference between sort of 1 to 1, like sort of 10 to 1 incidental collection, where you get 10, relevant conversations and 1 sort of incidental conversation, like the phone line situation, and the volume of data we're talking about in the context of 702, right?
Okay, but you just pivoted from 215 to 702, 2 very different volumes.
No, but okay, what Judge Leon was talking about, right, was that in general scale should be relevant, right, to the incidental collection analysis.
It's like Jones. Yeah, exactly. It's all and this highlights something that I think is one of the coolest things for all of you guys who are, especially the students who are first sinking their teeth into this. You're here right in a moment of extreme disequilibrium brought about by technological change, where the doctrine's in flux, and right now it's in flux. You've got all sorts of prospect, I think, likelihood for doctrinal change on things like third-party doctrine. And that wasn't true for prior years. We've been through long periods of stasis doctrinally. That's kind of an exciting time to be working on this area because you have a real chance to impact where it goes.
But just to try to tie this all back together. So part of why this matters, right, is because in thinking about, back to my attempt to sort of break things apart, right, in thinking about the substantive debate over the legality of 702, right, part of that depends in turn on how we answer some of these Fourth Amendment questions, which, because it has been so difficult to litigate 702, right, have never really gotten a full sort of fleshing out judicially.
So we promised to say something about there's a brand new law to mention here. So this warrant issue and whether and to what extent to make the criminal investigators go through a genuine warrant process before they can even try to query the database that's collected in the name of foreign intelligence gathering. There was a position that said, let's just subject anyone who wants to query it other than the foreign intelligence collectors in the first place, make them go get a warrant. The other position was no warrant at all. Once it's in the government's hands, everybody should be able to use it. I think it's fair to say they came down with a really watered down, but not non-existent, warrant requirement for this scenario. And at the risk of boring you guys to death, I'll try to just describe it. There's basically a complex statutory definition of when the FBI has to go to an Article III judge, not a FISA. No, it is the FISA court, right?
FISA court.
They have to go to the FISA court, not to get a FISA order, but to get an actual, what looks like a...
The statute calls it a warrant.
Yeah, and it looks like a Rule 41 kind of...
It looks like a Rule 41 warrant. Quacks like a warrant.
So when do they have to do this? It's almost easier to say when they don't have to do it, because that's how the statute's defined. So first of all, and you help me out here, guys. It only comes into play once the FBI's investigation has moved beyond the assessment stage, which is stage one, when they've gotten a tip about, Alex is up to something, I'm going to start looking around.
Please don't do that.
I can query the database because it's not yet proceeded to the stage of being a predicated investigation. It's only when it gets to be a more serious investigation where we've decided, all right, there's something here, now we're investigating you. Now the potential warrant requirement kicks in. But if it's categorized as a national security related investigation, not a foreign intelligence investigation, but a national security related criminal investigation, then no warrant requirement. Raises an interesting question.
So for example, if the theory is that Alex is providing material support to ISIS.
Right. Now, so the terrorism related stuff.
Sorry, Alex.
You can see,
okay.
you can see where that might
take this seriously.
I'll be the bad guy. I'm providing material support.
So if Steve's a terrorism related suspect, you can see where, okay, so obviously they'll categorize that as excluded from this new warrant requirement. What if it's not that? What if it's Computer Fraud and Abuse Act? There's really good reason to think that DOJ categorizes, in some of the early drafts of the legislation, categorize all cybersecurity type things, wire fraud, access device fraud, Computer Fraud and Abuse Act, categorically under the heading of national security on this sort of really broad theory that,
I didn't know that.
yeah,
Which also means
I'm here to help.
which also means stealing a password.
So now we don't know because the statute ended up not having a definition in this respect. So one of the interesting questions is, so how are they going to interpret that? Which raises a further question. If we've trained you well, to ask, yeah, I want to know how they're going to interpret it. I want to know who gets to make that decision. That's always the question. What's the process? Well, it's internal, right? So if they decide, if it's decided within DOJ that, okay, so all of Computer Fraud and Abuse Act counts as national security, therefore the warrant requirement is categorically inapplicable if it's a Section 1030 investigation, that in the first instance doesn't go to a court for further review. It's later on when they prosecute and there's a motion to suppress, or when
assuming that they provide the statutorily and probably constitutionally required notice to the defendant,
and assuming that there's not parallel construction to avoid this, which is where that whole incentive structure is into it.
Right.
So in recognition of that, at least somebody in the drafting process sort of sniffed out that that's probably a thing. So there's a specific call out for reporting to Congress of the study of that particular issue. How is this being interpreted? So eventually, for whatever
who in Congress?
Oh, well, the intelligence committee, but also judiciary, right? So.
Yeah, but
So there's that. And by the way, there's also a separate call out for reporting on, they don't call it parallel construction, but there's a reporting requirement that basically gets into how is the notification requirement being interpreted. So I think it shows at least somebody's interested in this, and they're going to begin creating some more of a record.
So imagine that the FBI thinks that I'm storing child pornography on my computer, right? And then we agree, for sake of this conversation, that that's outside the scope of a national security investigation.
Which I think it is, yeah.
Well, I'm glad you feel that way. Right, so then what happens under the new statute?
So then you got to get a warrant, unless there's further carve-outs. If the government determines that there is a serious risk of life or limb, and
so like an emergency exception.
Yeah, no, if it's just child porn stuff, then that probably not. But if there's some reason to think like somebody's actually, this could help identify a child in custody somewhere, someone's being held, then you could probably get around the warrant requirement that way as well. Of course, once you're talking on those terms, this is exactly where the government would like you to be talking about it. Like, don't you want that information to pass as quickly as possible? But that's basically the warrant requirement we got out of this. So there's a lot of stuff that's excluded, but there are a lot of kind of what I would describe as run-of-the-mill law enforcement that won't be able to get into the database.
So a more cynical way to look at the amendment is there's now a provision that folks can point to. Say, no, they can't just go query the database for your run-of-the-mill offense, right? And look, we've carved that out, despite the fact that if you actually really wanted to and you worked hard enough, you could probably find a way to get through it.
I think that criminal investigations come draped with the fact patterns that they're associated with, and there's a lot of stuff FBI does where 702 is going to be off limits to them unless they really want to try to get a warrant, in which case you could get a warrant anyway. It's like, why are you bothering with all this? Or why should we be concerned? It's the security and terrorism related material support cases that are going to be interesting because they are the ones where I think there's probably the most sensitivities, going back to Shahid's point about expressive freedoms and so forth, where people are going to be most alarmed about what kind of sniffing around might be going on. Is that fair?
I think that's absolutely true. I mean, especially when you think about the outer penumbras of material support prosecutions. I mean, this is not an issue on which EFF has taken a position, but just to note, like, the kind of fact patterns that have been reached under material support prosecutions. Tariq Mahana was a an academic, I think at Boston University, somewhere in the Northeast, who was prosecuted for material support for terrorism for translating documents for academic study. So if you translate ISIS
The government had a different view of.
it was at least the only thing that was established. I mean, maybe I'd have to read that with the but at least the concern that was raised by, I think of David Cole and others, was that this would chill academic translation. I think we have a question in the back. Absent coordination, or maybe a better example would be the Humanitarian Law Project case, where you've got a charity being prosecuted for material support for terrorism for providing nonviolent conflict resolution workshops in Turkey.
They actually weren't prosecuted. They saw a declaratory judgment that they couldn't be prosecuted.
Okay, got it. And then they were dissolved. That's
Right, but listen, the material support statute is incredibly broad. I mean, it's worth stressing that the oral argument in the Supreme Court in the Humanitarian Law Project case, the then Solicitor General, who we now know as Justice Kagan, right, was asked whether writing an amicus brief on behalf of a designated FTO would count as material support. And she said yes, right? So at which point I, who write many amicus briefs, thought more about my life choices. The point is that, right, it's not any one thing in isolation, right? It's the intersection of these authorities where, folks might have the most serious concerns about potential for abuse and manipulation.
Let's grab that question in the back.
You mentioned the function of FISA over the years, some of the things that have changed that. I was under the impression that there was a backdoor, an end-run approach where if a foreign ally is collecting data on civilians or persons of interest, and the respective agencies exchange those data, has that been used as a way to circumvent some of the legitimizations, or et cetera, and is that changed by the statute?
Sometimes referred to as the silver platter doctrine, that there's something you can't do, but your ally can serve it up to you on a silver platter. The relevant executive branch rules, for what they're worth, forbid this in terms of doing it intentionally. So for what it's worth, at least you have the formality of the rule saying don't do just that. I'm quite sure there are plenty of people who say, well, that may be what it says in practice, but people know how to wink, wink, nod, nod, and say, hey, you didn't want us to do this, but we happen to have this, and here it is. And so it's interesting because it kind of draws the line at, are you trying to engineer this? Did you try to make this happen? You can't do that. But if it just happens that Australia has something and they pass it over to you, or you have something, you pass it over to them, if you didn't orchestrate it, then it's not forbidden.
It's like reverse targeting versus purely incidental collection.
Yeah.
Maybe one thing I just add here.
I was going to say, as technology gets better, I imagine the NSA would like to collect as much information about foreign powers as possible. So if they have the capability of grabbing all of that, and allies have that same capability, there would be enough crossover where they would just have it available to you.
The technology part, it's worth stressing. Technology goes in different directions, right? And so, it is not beyond the realm of possibility that technological advances will also allow for better differentiation at the point of collection, right? That part of why we have the problems we have under 702 is because the government at least repeatedly represents, both publicly and to the FISA court, that it does not have the technological capacity at the moment of collection to segregate the clear sort of heartland 702 collectible communications from the incidental stuff that actually raises the concerns we've been talking about.
So I think that's true for about collection, but not for to-from collection, which I think is indeed really precise.
Even for MCTs?
MCTs is an about collection problem in particular.
Okay, fair enough. But so insofar as we're talking about multi-communication transactions where you're doing about collection, right? That you don't have sort of point of collection segregation ability, right? It's not hard to imagine a future where that changes,
right?
And where technological advancement actually facilitates the ability of the government to be more precise in a way that actually could, if properly regulated, ameliorate, right? Or at least alleviate to some degree some of the civil liberties concerns.
I want to say a couple of things here. So a few minutes ago, Steve was talking about the sort of alternative interpretations of the word incidental. And collect and search are other terms that are novelly interpreted by the agencies here, such that collection is presented as not implicating a search. And as Bobby was setting up later, the sort of internal requirement of a warrant requirement to constrain one agency from querying data that another one might have already collected, that the querying stage becomes legally interpreted as the search rather than the collection in the first instance. That's another point of substantive disagreement between advocates and the agencies. And another notion I wanted to try to seize here, it's eluding me. There were a couple pieces I wanted to make, and I'm sure it will come back. But
I mean, the government did try to argue at early points in, I think, the phone records litigation, that machine collection was not a search for purposes of the Fourth Amendment, right? And that it wasn't that the Fourth Amendment was not implicated until the moment in which a human being, working for the government brought their eyes to bear on the information.
What's interesting about that is, doesn't that give away their position on FBI criminal investigative access?
Right.
The backdoor scenario.
No. I mean, so
then suddenly, I guess you need a warrant.
Well, so I mean, there's that, right? But I think also the courts were, I mean, even the courts that ultimately sided with the government on the merits were not sympathetic to the argument that machine collection isn't collection, right? That a government computer is still the government for purposes of what is a search for the Fourth Amendment.
So it might be time to start moving into more normative discussions. Is the court where it should be, and if not, what direction should it head in?
In general?
About the warrant requirement, like the discussion we're having.
Well, so one thing we've kind of danced around, we haven't highlighted, is the metadata versus content distinction. But closely related to that, the third-party custody of the information versus your own custody of the information. As many people in the room will know, that the law of the land since the 70s has been, for better or worse, that when a company you do business with, like your bank, has your data about your bank account, as of course they do, that's how they run their business, or the phone company has the records of who you called, etc., you've lost your Fourth Amendment reasonable expectation of privacy because, of course, you've shared it knowingly with this third party. That doctrine was heavily criticized from the moment of its creation, but has been fairly steady for quite a while. And it seems very clear it's coming unwound as we speak over the past few years, and is all but certain to get at least a chunk taken out of it during the current Supreme Court term in the Carpenter litigation. It's already had a few nibbles around it. So in terms of like where are the courts in general on Fourth Amendment doctrine, I think the one place I think we can say with great confidence that at least for certain technologies that involve corporate America having data about you that is otherwise private, but they've got it. Under the old doctrine, that meant that the government could either compel them or could just ask for them to turn it over. I think that's very likely to change, at least beginning with, and maybe only extending to, the stuff that can be scalable. And that will include metadata. So the current debate's over cell site locator information, but we all understand there are a lot of other variants of this fact pattern. And so the question when the Carpenter decision drops is, are they going to somehow draft it somehow to try to make it only a change for cell site location information?
Yes.
Will it be broader?
No.
Will they actually leave the doctrine untouched?
No.
Jones was very limited to its facts of, property-based trespass surveillance. You have a question over here. And then, if you think about the doctrine of judicial minimization and avoidance, I think that could also constrain the court from reaching a more expansive.
I think we all agree, right, that the next couple of years are going to be a really important, potentially, point of inflection in Fourth Amendment jurisprudence in ways that are going to either directly or certainly at least indirectly impact FISA, the FISA court, all of this stuff going forward.
And this, before you get to Matt's question, this whole third-party doctrine, especially on metadata, has enabled the government in its foreign intelligence-based collection of metadata to not have to advance in court the argument that's the ultimate fallback, which is the claim that foreign intelligence collection doesn't implicate the Fourth Amendment at all, or that there's a...
Or at least the warrant clause.
The warrant clause, right. It still has to be reasonable, but you have to get a warrant. That position, for many years, in the 60s, 50s, 70s, that was the bread and butter position. And since FISA, it's never had to be contested, but a lot of the metadata collection that still continues under the USA Freedom Act framework kind of depends on that.
Matt, can I say one more thing before we get your question? So, if we ever get to a point where we're fighting over whether there is in fact a foreign intelligence surveillance exception to the warrant clause, I think it's real. This is where the sort of post 9/11 tearing down the wall shift could be hugely important, because the circuit level, the pre-FISA circuit level cases holding that there was such a thing as a foreign intelligence surveillance exception to the warrant clause were all predicated on foreign intelligence surveillance being the primary purpose of the investigation giving rise to that surveillance, right? One of the huge shifts after 9/11 is to get rid of the primary purpose doctrine. And to suggest that no, all that matters is that foreign intelligence be a significant purpose, I think is the statutory language now, right? That changes not only the statutory standard, but if we ever get back to the pure Fourth Amendment warrant clause question, now it raises, I think, a novel question about whether the foreign intelligence surveillance exception to the warrant clause, if it exists at all, extends to circumstances in which foreign intelligence is just a purpose of the investigation, not the primary purpose thereof.
So there's actually a ruling on this that then got vacated. This is the Brandon Mayfield case. This infamous
the District of Oregon.
This is the guy, the lawyer in Oregon, who incredibly fingerprinting foul up with the Madrid bombings suggested that his fingerprints were in the system for some reason, I forget which, unrelated to this, and there seemed to be a match.
His name was Eleanor Shellstrom. Okay, you guys don't watch The Good Place, because that was a good place.
No. So Mayfield basically wrongly indicated by fingerprint evidence, and it turns out he's Muslim. And so then the investigators are like, aha, this is a hit. It turns out it's all a horrible case of mistaken identity. But they had foreign intelligence surveillance collection. Suffice to say, a district judge actually reached the issue Steve described, and for the first time since the 70s touched on that issue and said, you know what? The primary purpose test is required by the Fourth Amendment. It hasn't come up for 30 years because of this other stuff. And then that opinion got vacated in connection with the settlement proceedings when the government had to pay him out.
Yep.
So that's looming out there.
Matt?
So yeah, I was just going to ask about the foreign intelligence exception to the Fourth Amendment, what that means and the history of it, because of course, before the FISA court, all of the foreign intelligence that was being done domestically was just being done under War Article 2, it wasn't being done with a warrant at all. And then with FISA, you sort of come in and you start to have these warrant-like protections, but they're not warrants, right? So for instance, in 2002, the FISA Court of Review has a case in which the government doesn't even attempt to contest that the FISA orders are warrants. They say, we're doing this collection under the foreign intelligence exception. So I was wondering if you could walk through some of the evolution of the foreign intelligence warrant exception, what it is and how it works.
If you go back to the 70s, we were on a clear pathway towards the Supreme Court answering the question, does the Fourth Amendment contain an exception to the warrant requirement when the government's purpose, maybe primary purpose, is not to prosecute, at least for now, but to collect foreign intelligence to inform government decision-making. There had been a predecessor case I mentioned earlier, the so-called Keith case, which arose out in Michigan, where a group of activists who were concerned about the CIA having a recruiting office, or they had some kind of presence in Ann Arbor, and in the night they set off a bomb at that location. They were being surveilled for intelligence purposes for some time, and then eventually were prosecuted. And then it all came out during the prosecution through the discovery phase that there had been warrantless surveillance. The defense moves to suppress the evidence and to have the charges dismissed. The government came back and said, listen, at that stage, we viewed this, there were people potentially going to bomb a CIA workplace, and this is all a bunch of, it's a Vietnam War protest, and they're concerned about the CIA's role in the world. So it was all an intelligence matter, and the government's position litigating was intelligence instead of prosecution. The Fourth Amendment just has to be read as not requiring a warrant. It's just a carve-out. Supreme Court said that may or may not be true if it was actually a foreign intelligence investigation. For example, if these people were like Vietnamese agents or Soviet agents, but they weren't. They were just good old American anti-war protesters for whatever that's worth. But they were concerned about foreign affairs, but they weren't agents of foreign powers. This was domestic intelligence leading then to prosecution. And the court said, and if they said, we are not opining what the rule would be if it had a foreign agent element. That's a separate matter. But for domestic intelligence, we will hereby say that it doesn't have to be a criminal investigative warrant, probable cause to believe a crime's been committed, but some kind of probable cause-based warrant is required, and we hereby invite Congress to create a statute that would, of course, look like the Foreign Intelligence Surveillance Act, only it would have been the Domestic Intelligence Surveillance Act. DISA. And DISA, of course, never was created. There is no DISA, and there are a host of reasons why. Basically, once you've once you have to go get a warrant in that context anyways, you'd have to have a criminal showing anyways. You might as well get a Title III.
Well, you could also argue that the Supreme Court in the years since the Keith case has also found more and more exceptions to the warrant clause.
Right, so there just was never any need, and also as soon as you frame it as domestic intelligence, it has this Gestapo feel to it. So there's never been much political impetus, and this is all unfolding right when Congress is trending reformist anyways. A lot of students will assume that, oh, I read the Keith case, I heard about this, it says a warrant requirement, so then they created FISA. No. FISA headed off the next case, which could have been a similar fact pattern, but presenting the foreign agent aspect of it. Because FISA's created in the meantime, you never really get to the foreign intelligence exception scenario.
You just get a couple of circuit level rulings in cases that arose before, where the irony is a couple of them, I think Butenko and one of the other, and Trong are actually after FISA's enacted, but the surveillance predated FISA. And so in those cases you get the Fourth Circuit especially recognize that there is a foreign intelligence surveillance exception in the warrant clause only where the primary purpose of the investigation was foreign intelligence surveillance. The FISA Court of Review decision from 2002, Matt, says there's no longer a primary purpose doctrine to get the underlying FISA order. But the Court of Review actually doesn't decide in that case whether there's still a foreign intelligence surveillance exception in the warrant clause. They do that 6 years later in the directives case, in in-rate directives, which was a case about the sort of precursor to 702, where the court says, even if this all implicated the Fourth Amendment, we believe there's a foreign intelligence surveillance exception in the warrant clause here. So the only decision on point, the only sort of post-Patriot Act, now that the district court in the Mayfield case has been vacated, judicial decision taken that we know of at least, seriously considering the scope of a foreign intelligence surveillance exception in the warrant clause with the demise of the primary purpose doctrine is the directives decision from 2008.
And that's binding on the FISA court judges, but not binding on anyone else.
As a practical matter, I think this distinction between foreign and domestic intelligence collection raises, as a practical matter, whether the courts are actually the institutions that are defining the rules. Here, insofar as if you think about the actions of executive agencies behind walls of secrecy, and I'm not even talking about federal agencies here, I'll talk about the Austin Police Department or the Tarrant County Sheriff's Department. Local, what we describe as street level surveillance, replicates the constitutional harms of 702, and it does it through an apparatus basically that evades judicial oversight only because it's not subjected to the FISA court process. When a police department runs off and gets a cell site simulator device, these are tools originally developed for military application that can be used to monitor cell phone networks, content, and metadata collected. The more recent versions of the platform have offensive capabilities that can hack and plant malware on devices. These have been used in the United States by domestic law enforcement agencies for 15 years, and they've only been objects of public discussion for 5 of those years, and it took a jailhouse defendant discovering that they existed in the face of non-disclosure agreements between the device manufacturer and the FBI, to which the Bureau and the Department of Justice were so committed that prosecutors were walking away from otherwise legitimate cases because they couldn't introduce the evidence gained by these devices without lying to judges about it. I think this story, which repeats itself in any number of other technologies, whether it's license plate readers or conceivably aerial surveillance drones equipped with facial recognition or infrared sensing technology, each of these different devices, as they've proliferated across domestic local law enforcement agencies, I think have essentially created end runs around this otherwise fascinating doctrinal question that I think is relevant only as this paradigm emerges in law schools, because on the ground the rules aren't determined by courts at all.
Although then that gets us back to why Carpenter is potentially such an important moment, right? Because the thing about the Supreme Court until 2010, right, had never seriously expressed reservations about the third-party doctrine. Not since Justice Marshall's dissent, right, in the Smith case itself. And then you get first, you start to get a little bit of this in the Kwan case about the pager, right, which the court sort of was able to duck the big questions because they find that the pager was owned by the city and so it wasn't really private. And then you get the Jones GPS case, right, where the majority relies on this sort of hyper-specific property rationale, but where you get Justice Alito of all people, right, writing a 4-justice concurrence about the sort of totality of the circumstances and the sort of pervasiveness of the government surveillance of, Antoine Jones. Then you get the Riley case, right, where the Supreme Court says, yeah, we have this doctrine about searches incident to arrest, but, cell phones are just different, right? Like the amount of information and the privacy of information that can be stored in a cell phone means that just because the cell phone's on you when you're arrested doesn't mean that the police can dump the contents of the phone without some additional suspicion. And Carpenter to me is the next step. I mean, I think it's entirely likely that the court will write an opinion that purports to be only about cell site location information. Riley, footnote 1, right, says this is only about the search incident to arrest doctrine. But what you're really seeing is a fundamental, incremental revisiting of this whole sort of foundation. And I think that has consequences that are both unique to the national security surveillance space, but also not, right? That are going to be felt by local law enforcement too.
For most of us, it's going to be the other, right? I think one reason why the court...
Except the casebook authors.
The casebook authors. It says we have to keep up. So one reason why the court was slow to come around, partly it's exactly what you would expect. An institution like the Supreme Court is going to take a while to catch up to the implications of changing technology.
I mean, Chief Justice Roberts asked at the Riley argument why anyone would ever have two phones.
Yeah. Well, so there's that. But then there's also the fact that Congress, so the court as a general proposition, when it thinks Congress is engaging, is going to be a little bit more reluctant to step in crafting doctrinal rules at the constitutional level. And this is where we get into the incredibly messy topic of ECPA and the Electronic Communications Privacy Act. So there's this pattern over time, whenever the Supreme Court, going back to the early 20th century, they issue a sort of a non-privacy friendly decision, and if it implicates enough Americans' interests, you often get Congress at least appearing to say, well, hold on, we'll plug that gap. We're responsive. So they say,
raise the floor by statute.
Yeah, exactly. So radio communication is not protected, or wiretapping, as long as it's effectuated outside the home. In the early 20th century, the Supreme Court said that as long as the wiretap's instantiated without interfering with the privacy of your own home, if they do it out in the street pole, then what's your beef? Which is something. So you got the wiretap type act at the time. In the 70s, when they said that your bank records are not reasonably expected to be private, well, you got the Financial Records Protection Act. Oftentimes, so these things look like Congress fills the gap, but when you actually look at the details of what Congress does, it's usually striking a balance somewhere well south of a warrant requirement. In 1986, they dipped their toes into the realm of protecting electronic communications that are in the hands of third parties. Emails stored on the server of the company, data stored by some company that's managing your data for you. And suffice to say, I think it's a famously convoluted, incredibly difficult to parse, and weirdly limited in certain time-defined ways as to how long you retain a statutory warrant protection for your emails that are stored elsewhere. And I think the court has been reluctant to get in this area in part because for years there's been talk of reform, of updating it. And every year there's a bill to update the Electronic Communications Privacy Act, and every year it fails for one reason or another. And I think perhaps part of what we're seeing too is the court's realizing that Congress isn't going to get involved in this, or at least not in an effective way.
I mean, look at the Microsoft case, right? I mean, so the Supreme Court is going to hear argument later this term, right, on the sort of, can a federal court in Manhattan compel Microsoft to turn over data stored on a server in Ireland, right? That's a question that screams out first. The case is not a constitutional privacy case. The case is about ECPA, or at least the Stored Communications Act part of ECPA. It's a case that has been screaming out for a legislative fix since the day it was filed. The concurring judges in the Second Circuit said, like, Congress, this is not the right result. Fix this. Right, and Congress has done nothing. So, this is not unique to this context. But I think the Supreme Court, in lots of other areas, is increasingly sort of aware of the, waiting for Congress to fix it one will wait a long time.
And just on that subject, I mean, it's worth noting that the dysfunction in Congress is multi-dimensional. If we think about the intelligence committees that were founded.
Do we have to?
Well, I think for students, it's useful to know, the intelligence committees in the House and the Senate were founded after the era that Bobby mentioned at the outset, when the agency's hands were caught in the constitutional cookie jar. And so, and what Congress found was so alarming that they wanted to create standing committees that would just continue this oversight function. And
they would have special declassification powers.
Right, and they've more or less fallen asleep at the switch. I mean, the idea that Congress is finding out, for instance, about the outer contours of 702 collection, not through the Intelligence Committee's ongoing oversight, but rather from whistleblowers, is really a shame on everyone involved in the system, including the members of Congress who are supposed to be conducting oversight, and the executive officials who are supposed to be answering their questions, truthfully. So that's one aspect of it. The partisan gridlock in Congress really constrains the body from having any intentionality. So, when courts are looking to Congress for some direction, trying to discern any direction from the chaos of that body is, good luck with that. And I think the last thing I have to say here is that, to the extent Congress touches things, it tends to be driven by, despite the deliberation for which the body is, supposedly renowned, not as deep reflection as we might hope. This recent vote, for instance, on the new statute that Bobby unpacked maybe 20 minutes ago is fascinating insofar as there was a vote in the House, it was less than a month ago, that was a divided vote. And what was particularly striking to me about the process that led up to it is that there were no preceding news cycles. And what we are seeing here is sort of the impact of a Twitter-focused press on policy discourse, which is to say the public had no idea this vote was going down until it had happened. And then between the Thursday when the House voted and Tuesday when there was a filibuster attempt mounted by 30 senators in the Senate, there was a very vast movement of the debate, and it was entirely because there had been no attention to the issue preceding, ultimately, what became a very decisive vote. And so the sort of knee-jerk process in Congress and its reaction to news cycles or lacks thereof, the deference to executive secrecy, and I think, quite frankly, also the institutional incapacity of members of Congress to engage this arena. And I don't mean to say that pejoratively, but unless you're on an intelligence committee, it's not clear that you have staff who are, for instance, cleared to access national security classified information. It's not clear that you will have staff who are qualified to interpret often very technically arcane practices and documents.
So I want to hear Matt's question, but I have a couple of thoughts in response to that. But Matt, why don't you go before me?
So I'm just curious as to the two different committees are very different.
So that's what I was going to say that, right? So the House, you mean House Senate or Intelligence Judiciary? Right. So I was going to say that I actually think the charge against intelligence committees is especially well leveled against the House Intelligence Committee, which near as I can tell has done absolutely nothing useful in 4 years of existence and has actually been affirmatively harmful even in the last couple of weeks.
You throw the entire history of the thing out.
Let me put it this way. There was at one of the first big public hearings the House Intelligence Committee held after the Snowden disclosures in 2013, there was this fascinating moment where the chairman of the committee asked one of the witnesses, why has no one complained about the phone records program? The previously secret, right, phone records program. Why did no one complain about the previously secret phone records program? And the witness, who was a bit of a schmuck, responded to the
The witness here.
The witness is here.
The witness speaking.
The witness is speaking. And the witness basically looked at the chairman and said, how could anyone complain about a secret program no one knew about? I thought that was an obvious response. To which the chairman of the House Intelligence Committee, who was not at the time Devin Nunes, said, Mike Rogers, right, CNN national security analyst Mike Rogers, said, well, obviously your right to privacy isn't violated if you don't know about it. Right? That was the chairman of the House Intelligence Committee. So I won't go 40 years.
Well, I was going to say, you certainly established it in recent years.
Right. At the very least, so I will say two things, right? First, that episode I think is indicative, right? Second, that we have not been made aware of any episode in the 4-year history of the Intelligence Committee where there was some important thing, right, where the committee actually asserted itself against the Intelligence Committee.
But isn't that the design? I mean, look, I think it's, like, I'll tell you what I believe about this, which is that when it's not a politically sensitive issue, when there's not a public spotlight shining on it, by and large, with all its warts and so forth, the Senate and House Intelligence Committees perform their basic functions within some bounds of what you'd expect in terms of, all right, receiving the presidential findings on covert action, receiving the briefings, pressing them, and none of us are ever really in a good position to judge whether they did what they should have done in response to that. It's when there's something that becomes a headline issue, and then all the wheels come off, because at the end of the day, they're all the elected members, and for the most part, with some very impressive exceptions, like the way that Senator Burr, I think, has been acting for the Senate Select Committee recently. Some of them can be more statesmanlike about it, and then others revert to political.
Well, this goes, so, and there are reasons why one would expect the Senate to be in a better position to sort of take the long view, right, than the House, in general, structurally, right?
Exactly.
But the last thing I just want to say, but so, way back when, the question that started this whole long thing was, reform-oriented, like, right, like going forward, what would we change? And it seems to me that one of the conversations we ought to be having, now more than ever, see Devin Nunes, is revisiting, right, not the idea of congressional oversight of the Intelligence Committee, I actually think it's very important, but the structure of congressional oversight of the intelligence community, including perhaps giving an even greater role to the judiciary committees, which by tradition are much more, I think, sort of skeptical, right, of government action, and more likely to press against the government, right, including perhaps changing the rules for who has access in Congress, right, to particular types of information. Because I think the House Intelligence Committee has not exactly covered itself in glory, at least in the last 5 years, Bobby, and certainly in the last 2 weeks, right?
And it's important to throw in all the other elements, right? So the system, it's a complex ecosystem, and I don't think anybody would defend it as perfect or even close to perfect, but it's a lot more than just the oversight committees, right?
Yeah.
So the Inspector General apparatus is a hugely important part of it.
And the FISA court. I mean, I don't think we're done talking about reforms to the FISA court. Like, I don't, so the USA Freedom Act has a couple of very modest reforms to the FISA court. I think we can have a much more aggressive conversation about increasing the ability of the FISA court to be an effective arbiter.
Well, the new bill that we mentioned from December actually contains a really brief and really important clause. It's now clear they can pay amicus to come present the public's perspective.
Although you know how I feel about them being amici and not parties.
Matt had a question?
So that's all true, I think, especially for the House intelligence. I think that the Senate has traditionally pushed back much more aggressively against the intelligence community. So, for instance, when you look at the CIA torture report, you can argue around the houses as to whether or not that was a good thing. I think the intelligence community acted very obnoxiously in a lot of that. But I think it's undisputed.
What you mean when they referred the staffers on the Senate Intelligence Committee to the Justice Department for prosecution?
After stealing documents
So
from the committee that had been
there's a
found
whole
in its
wide range of
investigation.
issues, but I think it's undisputed that the intelligence community did not want that dossier to be released,
Right.
and it was anyway. So there is some pushback there.
No, I agree.
Just to be clear, it was not released. The Senate torture report is never.
Well, the executive summary even though. I mean, there was pushback even on releasing the executive summary.
Yeah, I just mean to say the report remains censored, and no one has seen it outside the CIA.
So the unredacted one is still in a safe somewhere
In the DC District Court.
in the DC District Court, and the redacted one was released.
The redacted version of the executive summary.
Yes.
Which is just to say that the report remains censored. Like, that's just the top line there.
Yes,
And then-
the intelligence community, I'm sure, would prefer it even that.
I'm sure that's true, yeah.
But I think that there's a real problem with the amount of staff that the Senate has that are able to, and the House as well, that are able to see this information. You know, for instance, we've seen just this last couple of weeks that two members of the House Intelligence Committee were allowed to go and see the underlying FISA application, and two staffers. So this is an absolutely tiny number of staff who are actually allowed to go and see this information.
And apparently one of the members didn't read the footnotes.
And earlier, before the recent rounds of inquiries, when Congress was read into these programs, they were affirmatively denied the opportunity to have any staff present. The former chair of the House Intelligence Committee, that was Harmon, right?
Yeah.
And
Writes
with
the
the
note.
CIA torture report, they had to go to CIA offices in order to actually access
Right.
it, and that caused a lot of the problems.
Yeah.
So I think that there's a real problem. Congress doesn't have, or hasn't allowed for itself, the ability to access classified information in a way that allows it to do its job.
Well, and this is actually a phenomenon of the deeper problem that Bobby and I have been talking about on the at NSL podcast.
Tout the podcast. If
Right.
you're interested in this stuff, every week we have a 1-hour podcast on it.
So I actually think there is a more general problem historically that is not unique to the last couple of weeks of Congress not asserting anywhere close to the scope of its constitutional authority when it comes to classified national security information. You actually go back to 1954 for a second, right? A statute that gets very little discussion in national security laws, the Atomic Energy Act of 1954, one of the things that's actually really interesting about the Atomic Energy Act of 1954 is Congress creates this super sophisticated statutory system of national security classification when it comes to nuclear energy, right? Where there's no claim by, at the time, I guess it was Eisenhower, right, that Congress lacked the constitutional authority to set its own classification rules, right? That Congress lacked the power to have a say over what the rules should be for classification or not. That was the last time, right, Congress passed a statute meaningfully, sort of aggressively asserting its power to play a role in classifying or declassifying information, as opposed to giving the president the principal say, right?
They also have House rules that allow them to declassify.
So the House rule is not, it's not declassification, Matt, it's release, right? Under Section 11G, right, if the result of this week's contretemps is that the House releases the Schiff memo over the president's objections, it's actually not declassified. It's just released.
We just had a conversation recording this afternoon.
Right, listen to episode 58 of the National Security Law.
Yeah, what happens if the executive branch watching the House about to release it litigates to try to stop it?
Right.
And whether a court would get involved.
So I say all this just to say, right, that there is a much larger disease of congressional abdication that is not specifically about oversight of the intelligence community. I actually think it is much more generally about Congress just generally delegating and deferring to the executive branch on questions of national security secrecy.
And the executive branch having.
Security specific or just generally across the board?
I think it's more categorical in the national security space than we've usually seen. Like I think at least in sort of other normal administrative law contexts, there have been at least some efforts by Congress to amend the Organic Act to reclaim some of the authority over the years. Congress in this context has ceded the field so categorically that I think it would surprise Congress to learn that there was a time when Congress was much more directly involved in setting classification rules as opposed to creating procedures surrounding the executive branch's own rules.
And we should be clear that in the national security context, the consequences are far more grave. I mean, when we think about CIA torture, you're talking there about the country that waged a world war to establish an international human rights regime and sent a Supreme Court justice to litigate the case establishing strict liability for torture, basically covering up torture by its own agents. I mean, it's almost like losing the principles at stake in the Second World War 60 years after we won them. When you think of domestic searches unconstrained by judicial warrants, that's like losing the American Revolution, right? Like that's what the American Revolution was fought over, was the general warrants versus ones that were specific to time and place.
I think we're still anti-genocide.
I agree, but all I mean to say is that behind walls of secrecy, anything can happen.
So
and under this president,
so being mindful of
I hope
time,
that we don't have to revisit.
there was 2 questions that have been waiting to get in. Let's try and get through them super quick. Sir, you had a question, I believe.
Oh, I've got a lot of questions, but it's been 50 years since I sat in this very room.
We haven't changed.
So it's way too many
We haven't changed the decor at all.
I do want to ask you a few questions later on, though.
Great.
I'll refer to the rest of the class.
Okay, and then Kevin had a question as well.
Yeah, so I really like the point on, ultimately needing structural reform, because I find that, one way to get around human nature is to make structures that incentivize, and we're seeing basically that the Snowden revelations basically revealed that you, on the one hand, have a problem of the actual analysts being given this extraordinary power with very little oversight about the searches they can do. On the other end, the Congressional Intelligence Committees, because of partisan bickering, are not doing their oversight job. I almost think of a parallel sort of when dealing with nuclear situations, that, we literally have multiple keys that have to be turned before a decision can be made. I wonder if maybe you couldn't essentially use multiple cryptographic private keys to force every step of the process to be signed off on multiple people, and you can't enter that command until you've gone through the appropriate channels and the appropriate keys have been provided.
So I mean, I think we have to differentiate. So this is a common sort of thread in the post-Snowden debates, right? I think we have to differentiate between sort of ultra-virulent, rogue, right, government analysts. What the government calls euphemistically compliance incidents, right? When individual folks, right, are acting without authority and violate the rules and use their access to these databases for inappropriate purposes. I don't think you're going to hear anyone disagree that that's a problem and that's a problem that we have to make sure we have adequate sort of structures.
It's a problem in theory. I would very much disagree that there's evidence that that was a widespread actual practice. I know Snowden himself asserted, oh, any analyst can punch in whatever they want, and I don't think that's true.
No, but we
What
do.
about like London, though? I mean, we have documents.
Right, and those people got detected and fired.
We do
Are
know.
you sure that it's an exhaustive list?
Can I say,
Proven
right,
negative.
the Rule 13 of the FISA Court's rules, right? Rule 13b requires the government to report compliance incidents to the FISA Court, right? The government has gotten in trouble on exactly 2 occasions we know of for underreported compliance incidents. So at least
and self-reporting.
and self-reporting the underreporting. I'm way ahead of you. Okay. So the point is, So the point is, the FISA Court at least should have a relatively accurate, hopefully, number about how many problems those are. I'm much more worried about the authorized problems, right? Where the problem is not where no matter how many keys you want turned simultaneously in the computer system. I'm now thinking of 1950s, or the beginning of war games, right, where John Spencer is one of the technicians in the, right? No matter how many keys are being turned, right, the government is telling the right number of officers to turn them at the right time, right? And for that, no amount of redundancy in the system is going to solve that problem, right? What's going to solve that problem is having some opportunity to ensure that there is someone other than the government's own lawyers reviewing the government's interpretation of the relevant legal authorities, right? And that's where I get so worked up about strengthening the FISA court, strengthening the oversight process, Inspector General, just proxies, right? Someone who can stand in the position that the public would usually stand in to ensure that these legal interpretations actually withstand scrutiny, which in the context of the phone records program, it didn't.
And how do you insulate that individual from political reprisal or getting fired?
We have some tools, right? Life tenure is a pretty good one.
Statutorily independent inspector general.
Right.
Some of the inspectors general used to serve at the discretion of the appointing directors, and bit by bit, they've one by one been moved on to a statutorily independent term, which is obviously a key place to.
And life tenured independent Article 3 judges who only serve on the FISA court for a fixed and non-negotiable term of 7 years.
But I want to underscore this one because I think it's really critical to understanding how sometimes the NSA and the public were speaking past one another. So within the NSA, the reality is the day-to-day life of the people working there is this highly rule-bound, overseen, 2-key. Everyone knows there's audit trails. There's still screw-ups, but it's because of the scale of the enterprise that's unavoidable. And so they feel we're doing it by the book, and they think we're lawless, but they feel real compliant, right? But as their chief compliance officer, John DeLong, used to say, look, we're really good in enforcing our rules or making everyone follow the recipe. What people need to realize in the building is not everyone out there turns out to like the recipe very much. And that's your point, that it's authorized, and the question of whether the public knows and sufficiently supports what the recipe is and whether that's what we want as a society.
Well, so it's noted, right? I mean, I was on a panel once with George Ellard, I think, right, was the Inspector General of the NSA, right in the middle of the Snowden, George Allard, anyway, and so he gave this whole long speech about how Snowden should have come to him, right? Snowden should have come to me. I would have, he didn't need to go public. He should have come to me. And I turned to him and I said, and what would you have done? He said, nothing. I said,
Okay, so we've run a little bit over. We're going to have to get going. I don't know if anyone will be able to stay after the panel. I know Professor Chesney has to run.
I can probably linger for 10 or 15 minutes.
Okay, so if there's any...
The podcast it's a really creative title, the National Security Law Podcast.
at NSL Podcast on Twitter.
Yeah.
All right, great. So thank you to our panelists.